White & Case LL.M program. You've seen this morning what an incredible, stimulating environment we have here at the university. So I'm welcoming you on behalf of so many of our faculty who are here and members of MIAS, and so many of our students, the current and the past. They are fabulous, and it all creates such a wonderful, stimulating environment. And we're honored today to have with us Juan Fernandez-Armesto, who is just the best. He, in fact, is known as one of the most in-demand arbitrators. And we know from all of his achievements, of his incredible substantive excellence. If you read any of his awards, you know, whether they're commercial or investor state. But he comes from a background that really informs what he's able to do and how he's able to lead. Having been a partner at Uría and Menendez, one of the biggest Spanish firms, president of the Spanish SEC, professor of commercial law, and presiding at or sitting on hundreds of tribunals. He's the real deal, who comes with the whole package of experience to give him the substantive and procedural ability. But I think most of all, he is always a pleasure to deal with. Whether you're on a panel with him or in an arbitration, he treats the parties well, he treats the advocates well, he does an incredibly diligent job at his task. You can't ask for a lot more, but he throws in a little bit of levity on top of it, which is always welcome in intense situations. So this is a treat for us here at Miami, and on behalf of our wonderful community, thank you for being here.
Thank you, Carolyn. You will not believe it, but I think this is the first time in my life that I feel like an abbot. Because you know that this tradition of having someone speak while the others eat is typically of monk monasteries. The difference is that monks, what they get read at is the lives of saints. So I thought whether today it would be appropriate to bring some appropriate saints regarding arbitration and to tell you the lives of those saints. But then on reflection, I thought maybe it would be first difficult to find the saints who have a relation, because I would say that most people who are in arbitration will never become a saint. And then maybe it would be very boring. So what can I tell you at lunch, which has something to do with investment arbitration and is not too boring, because most topics in our profession tend to be boring. So I thought cases, because if you tell cases, cases are always interesting. And I will tell you 2 cases and a half, because maybe we'll run out of time. But I will tell you, and there is a thread, which is denial of justice. Some cases of what we now understand about denial of justice, how that came into being. And the first case is not an investment arbitration case, is Barcelona Traction. That, if you, in a nutshell, is a private, it's a Spanish case. Let me also say that my former senior partner was defending Spain on that case. And it is, by all accounts, a private expropriation through denial of justice. And it was dismissed for lack of standing of Belgium vis-à-vis Spain. But that is the legal story. I must tell you the real story. And the real story is the expropriator was not the Spanish state, but was Spain's wealthiest man, Juan Marc. And he is really a colorful character. He was called the last pirate of the Mediterranean. And he was sort of a Spanish Rockefeller, but with more Spanish, with Spanish character. And he started as a smuggler, became wealthy beyond belief. And during the Spanish Republic, so in the 30s, they put him into jail. And two anecdotes, just to show you the type of person he was. He was in jail, but he bribed, I suppose, all the jail authorities. So he had a secretary, 2 rooms, and he lived in style. And the style included that every day he would send a note to the Palace Hotel in Madrid saying, for tomorrow I would like for lunch asparagus and beef, and as dessert, type of quality of the lunch we have received today. And the Palace Hotel would then serve that to his jail. And on the day before Christmas, he made a note and said, well, for Christmas I would like, and he made a long list, turkey and all these things. In the next cell was this is historic, this is not made up. In the next cell was a famous forger of signatures. And he got the note, and he added then in the similar handwriting, and please do send the same dinner for the 285 prisoners of the... So he was Spain's wealthiest man, the best client of the Palace Hotel, which you can still see today in Madrid. The hotel received that on the eve of Christmas. They stopped everything. The whole kitchen worked the whole night. They got a truck, and on the next day they trucked 286 dinners to the prison. And of course, Don Juan, he ate alone in his room. But after dinner, suddenly, prisoners came in and said, Don Juan, thank you very much. That was the best dinner in my life. And the next one came, thank you, Don Juan, really appreciate it. We will never forget. And he didn't understand anything until finally he understood that his note had been forged. And to his honor, he never disclosed this forgery. And then the second anecdote is, he of course got then into a good relationship with the director of the prison. And they started speaking, and he said, well, this is a very well-organized prison. And the director said, well, yes, of course, we do what we can, it's important. Oh, my business is so poorly organized, and I needed a man like you. Long story short, he hired the director of the prison. The director of the prison came one night in with disguise of a bishop, went into his cell. He put on his disguise as a bishop, and both of them walked through the door of the prison. A car was waiting, and before anyone noticed that he had fled, he was in Gibraltar and outside Spain. That was in the Republic. He then is famous for having bankrolled Franco. He is the man who put the money for the Spanish Civil War. And one side. The other side is Barcelona Traction. Barcelona Traction was a multinational which produced 20% of the Spanish electricity. It had Belgian shareholders, but they had a special purpose vehicle in Canada for tax purposes. And they had issued in the 1915s a 50-year bond in sterling. And they had a bad reputation. As many multinationals have, they had a bad reputation in Spain. And so in the 1940s, during the Second World War, Don Juan Marc said, that would be a nice objective to incorporate the Barcelona Traction into my empire. And he made an offer to buy it. And the Belgians rejected. But the Belgians had weak spot. They had issued these bonds in sterling in London. The company was very successful and very profitable, but it was the 1940s. Spain did not give any authorization to send out money from Spain to pay in sterling, because Spain wanted to conserve its foreign exchange. And so, after having his bid rejected, the next step was February 1948. Reus is an obscure little town somewhere in the province of Tarragona. And three gentlemen walked in to the court and said, we have bought these sterling bonds. They have not been paid for 10 years. They have been issued by this Canadian company. And you, dear judge from Reus, you do have jurisdiction over that company because it has a subsidiary in Spain, and yes, that subsidiary is in Barcelona, but that subsidiary has a power plant in Reus. And so you have the jurisdiction to declare the bankruptcy of the Canadian company. The three men are well known to be men selected by Mark. And the judge applied the 1829 code of special commercial code of Spain, which said that if a company, if a merchant ceases to pay the debts, then the judge ex parte can declare him bankrupt. So he said, okay, I will do that. And he declared this huge Canadian company bankrupt. And then the judge had a difficulty, how to notify that to the company. And he said, I can't. I really don't know where in Canada this company is. So he said, I will do the next best thing. I will publish the notice in the official gazette of the province of Tarragona. And yeah, and so the Canadians and Belgians had the very bad habit of not reading every day the official gazette of the province of Tarragona. And they had 8 days to react and to oppose. And they didn't, because they didn't know. And nothing happened in these 8 days. And then the 9th day, the court-appointed receiver went to the Barcelona offices and said, good morning, we are the court-appointed receivers, and we take control of the Barcelona fraction. And when the Canadians, Belgians eventually noticed that they have been declared bankrupt, they went to the judge, and the judge said, yes, bad luck, you had 8 days. You presented your opposition 40 days after the declaration, and it's too late. And they went all the way up to the Spanish Supreme Court, and they always were defeated on the argument that they had been late. And then the next thing what the receivers did is, this is an utility, we have to do something. So they made an auction. And they sold all the assets of the Barcelona traction. For how much? The minimum price was 10 million pesetas, was a pittance. And the only participant was a company in the auction, was a company controlled by whom? By Mark. And since he was the only participant, he got this huge company for 10 million pesetas. So your next question is, of course, these 10 million pesetas were then delivered to the Canadian company. Oh, no, 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 no. Why not legal costs? Huh? You have legal costs, you have lawyers, you have the receivers, they must collect. So eventually, how much money did the Belgians receive? 0. So that is the real story of the Barcelona traction. So fast forward to 1970. Belgium then started, as you all know, an action under diplomatic protection against Spain before the International Court of Justice. And then in 1970, José Luis Bustamante, a Peruvian president of the court, read the famous decision of the Barcelona traction after 12 years of procedures. It was really the first modern procedure. Hundreds of lawyers, huge costs. The merit phase was like 5 years. And there was two jurisdictional objections which the court had joined to the merits. So they had heard the whole merits. They had gone through the whole argument, denial of justice, the Spanish bankruptcy system. They had gone for years through that. And then came out the judgment. And this judgment, let me tell you a story. I was 9. 9? Yeah. 9, yeah. Oh, a bit older. But my father was a journalist in Germany, and I perfectly remember him being called to the telephone, and he coming back and saying, "This is the most amazing thing I have seen in my life. Spain has won against Belgium." Because the political background is Juan Marc, the man who bankrolled the Spanish Civil War, who was evidently paying for these hundreds of lawyers. Spain did not pay a single cent of that. Belgium, a democratic country belonging to the European Economic Union, and Spain won. And the amazing thing is that Spain won unanimously. The amazing thing about the Barcelona traction judgment is it's unanimous. I mean, there was this ad hoc judge designated by Belgium, but this is like party-appointed arbitrators. I mean, we all know what they decide. Huh? We all know what they decide, but the rest was unanimous. Huh? And it was rejected because Belgium had no standing. No? The arguments, you know them, that international law recognizes personality of corporations, and diplomatic protection corresponds to the state whose nationality the corporation has. So the corporation was Canadian, and the standing corresponded to Canada. And there was, of course, an elephant in the room, namely denial of justice. What happened? No, there is no word about denial of justice in the decision. There are two separate opinions which deal briefly with denial of justice. The one is Tanaka, the Japanese judge. Now, it is, I'm sure all of you have at some stage quoted the definition of denial of Justice Tanaka. Most people don't know that Justice Tanaka said, and that definition does not apply in this case because Spain did not commit a denial of justice. You are always quoting a definition from one who said, and there is no denial of justice. Which is amazing. I don't really understand how Judge Tanaka, but maybe he did not understand the facts. And the only really who got some understanding of what was happening was it's as so often, an English QC and Judge Fitzmaurice. He voted for Spain. He voted for Spain, and he said, well, maybe the notification by the judge of Reus in the official Gazette of Tarragona, maybe that could constitute denial of justice. So that is the famous Barcelona traction case, told as someone who has lived, at least through my senior partner, in the reality. And of course, it was such a disaster of a case that it was the demise of diplomatic protection. I mean, I don't think that it disappeared. I mean, and it has been substituted by what we are today seeing. And then came all the bits, the BITs and the treaties. And one interesting thing is the following, namely, I only know one treaty where the words denial of justice appear. Only one. It's between the United States and Peru, I think. Further to that, I have never seen a treaty where you have the words denial of justice. So, and we spoke about literal interpretation of treaties. So you would say, well, of course, if it's not mentioned, there is no denial of justice in treaty protection. Well, it is not. And that that there is protection in the treaties for denial of justice, that comes from another case which is also interesting, which is Leuven. And Leuven is a Chapter 11 case. You, of course, know it's one of the most prestigious tribunals ever, and I will not, and this is not a joke, I will not criticize it. I will just explain to you how I see it. And you know, it is a Canadian group, Leuven Group, and they had a contract with a certain gentleman from Mississippi who was called O'Keefe, and it was a small contractual dispute for $4 million, and there was a jury trial, and this Canadian company had to pay $100 million compensation and $400 million punitive damages. To appeal, they had to put a bond for $625 million, and eventually, as you know, they settled for $175 million. And then the Canadian corporation and a gentleman called Leuven, who prima facie, one would assume has something to do with the company, they started this NAFTA claim against the United States. And what did this extremely distinguished panel of judges do? They did a Barcelona traction. But they did the Barcelona traction with a little bit of add to. The Barcelona traction is when, after having heard the merits, you dismiss the case because the claimant has no standing. And they made an argument, and it is an international law argument. I'm not a specialist in international law, and I have no idea whether it's true or not under international law, if there is anything called international law. I come from private and commercial law. This is why I have some doubts about whether international law is really a system of law. But this is off the record, definitely off the record. But then they could have done a full Barcelona traction. They didn't. I think they had mens rea. They had mens rea. They didn't feel well. And so they made this most astonishing, that is the biggest, the largest obiter in the history of decisions. And yeah, but it is, yeah, they apologized, but in a huge obiter. And the obiter, I will now summarize it. The first point is that they analyze this trial in Mississippi, and they say, and it's a miscarriage of justice. So they say, yes, it's a denial of justice. And then they say something which is really important. They say, and this denial of justice is a breach of the FET provision in the NAFTA treaty. And they set this precedent, and from there we all draw. And it is really an important, it is good that they make this obiter because it is important for the future. And then they said something which is also their decision, that customary international law requires, is incorporated in this denial of justice concept, including the exhaustion of local remedies, which is not self-evident, And then they say that Leuven had the possibility of accessing the US Supreme Court through something which is called a certiorari, whatever that is, and that consequently they had not exhausted local remedies, so that even if they had standing, there would have been a denial of justice, but they would have been thrown out because they had not exhausted local remedies. So this now leads us to how the situation stands now. And the situation stands now, it's not self-evident, and it is, I draw your attention to that. Take a municipality in Andinia, and the municipality of Andinia prohibits the foreign investor to access the mine, okay? And let's assume that this is a breach of FET. There, in that case, there is no exhaustion of local remedies. You do not have, the investor does not have to go to the local court, first impugn the decision of the local mayor. The investor can go directly to international protection. Now assume that it is not the mayor, but it is the local judge who does that. Then the decision of the local judge is a denial of justice, but you have to appeal the decision through the whole system if you apply the principle of Leuven up to the Supreme Court of Andinia, which is, it's a slightly, but we can discuss it. We can discuss it whether, but that's how we all interpret the law. And that takes me, then there are hundreds, no, hundreds is false. There are dozens of awards which basically repeat the same idea of Leuven. And basically they say, yes, there is denial of justice, fits into FET, and you have to exhaust local remedies. Now, most of them never apply denial of justice. I mean, they define denial of justice, and then the next paragraph they say, but, bad luck, your facts do not fit that standard. And there are only a handful of cases, Flughafen Zürich, Dancake, Manchester, but Manchester has been annulled. There is Lyon, and there is one case with which I will finish, and as a homage to Johnny Wieder, and that is Chevron versus Ecuador, and I will just tell the story because it's so amazing, and it's such an interesting decision because it's a fact-driven decision. And what had happened there is Chevron was claiming against Ecuador because Chevron was saying that in Lago Agrio, a judge called Judge Zambrano, had committed denial of justice. And he had committed that by issuing a judgment which ordered Chevron to pay for environmental damage, 18 billion plus $8.6 billion in punitive damages. And the whole argument of Chevron is, it was a very well-drafted judgment, very well-drafted, 180 pages, and really consistent judgment. And the whole argument of Chevron was that Judge Zambrano had not written it, that the claimant's lawyer, the lawyer of the claimants, that they had delivered the judgment to Judge Zambrano, and he had just signed. And Judge Zambrano, who appeared in a RICO procedure in the States to defend his innocence, had deposed, I suppose under oath in the United States, that he had himself written from the first to the last word of the judgment. And what is amazing about the case of Johnny Wieder, and it's a wonderful read, is how Johnny Wieder analyzes the facts and builds the case to prove on the available evidence that Judge Zambrano's statements cannot be true, and that the only possible explanation is that the judgment has been written for him and has been delivered to him by the local claimants in Ecuador, and that he must have done that in anticipation of a bribe. And it is a very fact-driven, I mean, the factual analysis is 100 pages, and it is it's a very, very, very well-written, very well-researched decision. Once you have come, of course, to the conclusion that the judgment had been rendered by the claimant on behalf of the judge, the necessary conclusion, like in so many other cases, it all hinges on the facts. Once you have proven the facts, if the facts are an elephant, the consequence is denial of justice. And now comes the worst part. This is the cross-examination by Carolyn Lamm. I have not slept tonight.
Well,
I come from commercial law, Carolyn. Do have, let me, this is like in an exam. Madam Professor, I'm a specialist in another subject. International law is...
Well, you really have brought alive the cases that we've all been arguing for years. What a fabulous, fabulous speech. Thank you so much. But it is incredible with the Barcelona traction case that you've told us about. What an unbelievable set of facts. I'm not sure the ICJ had all of it before them, but it did turn on the nationality, of course. And there is in the dictum of the decision, paragraph 102 in the ICJ's judgment, and I want to quote it because I then have a question following on this. The ICJ acknowledges we've had, as he indicated, 12 years of incredible submissions. And the quote is, "It has been argued on one side that the unlawful acts had been committed by the Spanish judicial and administrative authorities. And as a result of those acts, Spain has incurred international responsibility. On the other side, it's been argued that the activities of Barcelona Traction and its subsidiaries were conducted in violation of Spanish law and caused damage to the Spanish economy. If both contentions were substantiated, the truth of the latter would no way provide justification of the former." So you see a little bit of acknowledgement that the unlawful activity would not be a set-off. And the ICJ apparently takes the view that the conduct of Barcelona Traction and its subsidiaries was in violation of Spanish law, and in no way such illegality really would provide justification for a denial of justice. Given that, and the incredible facts you've described, do you see a tension here with the later jurisprudence that's emerged in the investor state tribunal's decision of similar actions, where an investor's unlawful conduct in fact may result in the dismissal for lack of jurisdiction or inadmissibility?
Thank you, Carolyn. Can you keep a secret? If I say that the International Court of Justice had some hypocrisy, will you all keep that secret? The Spanish argument, the Spanish defense was very cleverly based. This is a multinational. I told you at the beginning, this is a multinational, and it has misbehaved. And they collected quite some significant evidence on that. And of course, the International Court of Justice says, no, this is irrelevant. You cannot set off denial of justice with misbehavior of the companies on completely different levels. And legally speaking, that is true. But the question to you is, it's 1970s, it's the moment of time against colonialism, multinationals. Do you think that the judges, the Judge Tanaka, that Judge Bustamante, that they were not somehow influenced by these, not legal arguments, but let's say these good faith arguments which Spain was bringing up? So I think that what I would take here as a lesson is do bring up arguments saying that either the claimant or the respondent have been behaving in bad faith, because it has at the end some impact on the adjudicator. Adjudicators want to do justice, equity. And so these things, I think that the argument of Spain was, although technically it is dismissed, in the heart of the decision makers, I think it had an impact. And of course, what Spain was saying is not what now is being argued in all investment cases, because the investment in Barcelona Traction had been done in the 1910s. It was saying that 20, 30, 40 years after having invested, that they were misbehaving in the market, that they were abusing the market, dominating the market, excluding competitors, giving bad service. I mean, the type of things states like to say.
So kind of a quantitative assessment. It wasn't quite enough to overcome.
Yeah, it had nothing to do with investment. The investment itself was not subject to any doubt.
So now poor Mr. Lowen, in the facts as you described them. It is an amazing case. I'm sure all of us have struggled with Lowen and the outcome in Lowen. And, you know, it's interesting that the tribunal adopts the denial of justice standard from the Mondev case, which regrettably we lost on denial of justice, even though that too was a horrible, horrible situation. And what they're referring to in that case is the question, according to the tribunal, is whether at an international level and having regard to generally accepted standards of administration of justice, a tribunal can conclude, in light of all the facts, that the impugned decision was clearly improper and discreditable, with the result that the investment had been subjected to unfair and inequitable treatment. The Lowen Tribunal, extraordinarily, explains that manifest injustice in the sense of a lack of due process leading to an outcome which offends the sense of judicial impropriety is enough. How they could say that and then say that decision, which is in breach of municipal law that you note they added, and is discriminatory against a foreign litigant, amounts to manifest injustice according to international law. So we have both legal systems and we have a guy who loses. How gross and manifest must an injustice be for a claim to be successful if what you, as you note, a tribunal is trying to do some sense of justice in making its award?
Three answers to that, I think. First, and maybe we come later to that, I think all denial of justices are procedural. At the end, the only thing which an international adjudicator can review is the procedure. And we can then get into the point of exactly what we mean by procedure. It's always procedural. I think Leuven is not right in when they say discrimination, that there is that a necessary requirement is that this judgment was rendered because it was a foreigner. I think it is enough if it is really outrageous, it's bluntly manifest, it's a very serious breach of due process, which really shocks everyone. The discrimination, I mean, that word discrimination there, and I do not think it now, if you ask, you review all the other cases, that the element discrimination is a requirement. It helps, of course. If in the Leuven case, I think that the judge had made references, this Canadian multinational and so on. There was an element of discrimination, but in most of the modern cases, you will find that the discrimination element is missing.
And while the standard is formulated, and you allude to this in what you said, in an objective manner, doesn't it really leave a fair amount of room for subjective judgment?
Is there anything in investment arbitration where there is not subjective judgment?
Well, it all turns on the facts, as you know.
Evidently, it all
It
turns on the facts.
You don't have the same facts in every case.
You win or lose your case on the facts. Because if the facts really are so outrageous in the eyes of the adjudicator that they are not fair and not equitable, or they are such a breach of due process that the adjudicator feels this is totally improper, then however you define the standard, we are all lawyers and jurists, and we love to define standards and to define words and higher standard, lower standard. But at the end, it's all prove me the facts and provoke in the adjudicator a sensation that these facts cannot be reconciled with whatever general term you have in the rule, be it FET, full protection and security, denial of justice, whatever, expropriation, even expropriation, indirect expropriation. There's quite some discussion on what could be or not an indirect expropriation.
Yes, and as you noted, of course, there is only a denial of justice phrase written into one treaty.
To the best of my knowledge, yeah, I may be correct, I have only found one.
So it kind of creeps in under FET.
Yeah, absolutely.
And, you know, I want to take you to...
Which is not self-evident.
It's not self-evident.
It's not self-evident. I mean, if you interpret treaties literally, fair and equitable treatment seems to be something separate from denial of justice.
Well, and our friend, and certainly my predecessor in chairing this program at the University of Miami, Jan Paulsen, devoted himself to writing an incredible treatise on denial of justice in international law. And he does say...
He's still the authority, huh?
He is the authority. Absolutely, he is the authority, and on almost anything he wants to speak on, but he, of course, indicates that denial of justice is procedural. But it's also the least elucidated concept, I think, that we struggle with. And he notes, and this is a quote, maneuvering the line between what appears to be substantively unjust and what is unjust or erroneous because of gross procedural breaches is the greatest difficulty with our subject. And he goes on to note that gross or notorious injustice, whatever the words used, is not a denial of justice merely because it appears to be demonstrably wrong, but it must impel the adjudicator to conclude it could not have been reached by any impartial judicial body worthy of that name. So
it's the same.
It transgresses into the substantive area when you're trying to analyze that context, doesn't it?
Yes, because I mean the quote from Paulsen, which is frequently used, and I fully agree with it.
Yes.
He basically says the following, I mean, in normal speech, all denial of justice is procedural. Okay. What do we do if we see a decision which is absolutely unjust, is materially, is from on the substantive point of view, totally unjust and unreasonable and incomprehensible? Can you say that that is denial of justice? No, because it's not a procedural question. Well, except, of course, that a judge, to get to that result, must have had a biased attitude, a procedural preference, and then you reconduct what is really that you find the decision deeply unjust into no reasonable, unbiased judge could have taken that decision. Consequently, there must have been a procedural issue. Consequently, thank goodness, I can label this case as denial of justice. At the end, this is what I want. At the end, it is fact-driven. You must convince the adjudicator that the decision is either taken by a blunt breach of procedure, or it is so unreasonable that no good faith, reasonable judge could have taken it. It reminds me, and Gonzalo, I'm stand here to be corrected, annulment, ad hoc annulment committees. I always say the most important thing for an annulment committee to annul an award is that they are convinced that the award is very unjust, very wrong, and then, if they are convinced, they will find a way to put it into one of the categories of the exit convention. But if they are not convinced that it is wrong, they will never annul it, and they will find a way to say no to all the requests for annulment. At the end, I think adjudicators, they want to do justice. They want to have a result which is just. And at the end, this is why the facts of the case are so important.
Absolutely. Well, that takes us to the last, which is the Chevron case. I think you did a masterful job in describing what Johnny was doing in using everything to prove what had gone on.
Do read it. Do read the decision. It is really very instructive of how one goes about proving denial of justice.
And at the end, of course, as found by the Chevron tribunal, it appears to be the extreme end of the denial of justice spectrum. In view of this incredible factual background, though, do you think they set a bar too high?
This is, again, this wordsmith. No, you say wordsmith or wordsmithery. Because we define bars, and then we say the facts fit or do not fit, and I raise the bar because the facts are very high, so I can raise the bar. Can I say it? It's a play of words. It's play of words. This is my personal opinion. It's play of words. At the end, all adjudicators, all judges, all arbitrators, they make a wholesale review of the case law, of what the law says, and then they take a judgment. I'm sorry if I disappoint you with my very blunt...
In this area, that should be a good thing, because all of these have been so unjust and they've gone off on a technicality. It's a bit surprising. But in any event, I think now let's hear from the students. Do we have a question?
Yes, we have. Yeah. Can you stand up? I really don't hear you.
Hello, thank you, Juan, for that presentation. And it's precisely going to the point about this distinction between procedural and substantive. Because on the one hand is a tried proposition that investment tribunals are not courts of appeal. And on the other hand, there are standards to be upheld. That's why we have claims for denial of justice. So the issue is how to reconcile these two. And seemingly the compromise that, for instance, in the Lion case is to say, well, the analysis is only going to focus on procedural issues, right? So denial of justice is only procedural. But then the question becomes, well, how really you draw that line? And that's extremely difficult to draw that line between procedural and substantive. And for instance, you just gave two different examples or potential standards. One was a judge who respects due process. Okay, fine, if due process is fully respected, then in principle we would say there is no denial of justice. But then on the other hand, there was this other standard that I think you mentioned from Paulson's work, saying, okay, did the judge reach a decision which no reasonable adjudicator would have reached? And that standard allows, I would submit, for for a substantive view of denial of justice? Because it could be that that judge in that example that reached a decision that no other reasonable adjudicator would have reached fully respected due process. It could be that that judge fully respected due process, but still there is something, perhaps some conclusion that he reached on a factual issue in dispute or on quantum that perhaps another adjudicator or an investment arbitrator would say is not properly supported. And would that be, for instance, procedural or substantive? So I wonder whether there is some rational basis to draw more meaningful distinction between procedural and substantive.
Let me try. It's a very, very good question. And let me say something, because I have here Gonzalo from ICSID, and under the Code of Ethics of ICSID, I am not supposed to comment anything on Lion, so I will not be commenting on Lion. Let's make practical rules about this, because otherwise we may end up una empanada mental, I mean, with however you say that in English, okay? First case, normal case. Denial of justice is procedural. It's either you are not notified, or the due process is breached, or you are denied the possibility to present evidence, or you are denied the possibility to appeal, or there is some other serious breach of due process. That's the normal case. If you are pleading a case of denial of justice, please start pleading it procedurally. There is not, I have never seen a lawyer who will not find in a judicial procedure some breach of due process. Lawyers always find one or other reason to plead that there was a breach of due process. You, Carolyn, agrees. Huh? So that is the normal case. And then do plead also that the judgment is bluntly outrageous. That is the normal. This is how I would present a case for denial of justice. And the tribunal will then look at the due process and say, due process has been breached, this is denial of justice, and your case is successful. Or if you are arguing the other way, say that the due process has not been breached. You then put this highly theoretical situation where the judge is the perfection himself or herself in the process. Not one single breach of due process. And then after this perfect process comes a manifestly unjust judgment. Now this is nice for universities to discuss. This is not the real world. This never happens, because all these cases are cases where local judges misbehave. But since we are in academia, let's now take that discussion. No? What now, for that academic case, what Paulson says, and I think I agree, is he would make the argument that no good faith, independent, impartial judge would issue a decision which is bluntly, outrageously, totally unjust and contrary to municipal law. Consequently, he must be biased. If he's biased, there is a breach of due process. If there is a breach of due process, it could be a denial of justice. That is his way of thinking. Did I help you? Or you look even more...
No, it's fine. But I wonder whether then just that recharacterizes every substantive breach as bias and then just goes back to procedure. Okay.
Yeah.
Fine.
I think that is the interpretation. I stand to be corrected. I'm not Paulson, but that is, I think, how he reconciles those extreme cases of perfect procedure and blatantly wrong decision. By the way, to all the students, don't go disheartened from today, because you may think that investment arbitration or arbitration protection will disappear, and that that all your efforts to get to know and to specialize in this matter is in vain. And not at all. Not at all. I mean, investment protection is important for the development of nations. And it is important for all Latin American countries because it's the only way to attract high quality capital at a reasonable internal rate of return. And what we are discussing is who should adjudicate the decisions, whether it's a court, whether it's arbitrators. But for lawyers, it's the same. I don't think for lawyers it will be significantly different to plead in front of a court or in front of arbitrators. Maybe the profession of arbitrator, like mine, is a dinosaur. We are going to be extinguished together with Gonzalo. But for practitioners, the future is bright.
So do we have another student question? No? Okay. Audience questions. Time for one. Yes?
Hopefully someone who disagrees with me.
No, unfortunately, no. So this is Robert Dunlap. So my question is, how is it that, you were mentioning that it seems kind of unusual that we have a treaty that has its own standard, fair and equitable treatment, yet this due process standard from international law gets incorporated into the treaty and limits that standard in the very specific circumstance of a judge who has taken some activity. It's not just hard to understand, it's like, I don't understand and wonder what's the best logical explanation for limiting the rights of an investor based on language not in a treaty, when the treaty is clearly a new contract designed to provide new rights and to spell out the obligations on its face. What's the logic of LL.M that limits that?
You mean because of the exhaustion of local remedies?
Correct. Well, I think it incorporates the denial of justice standard from general international law principles that pre-existed, even the BIT system. And so why should those procedural requirements be read into a new contract, which seems to provide far more rights and far more flexibility?
Why don't you ask that to the very distinguished judges who made it? I am puzzled. I am as puzzled as you are that the end result is states have take three types of actions. No, they take legislatives. They pass regulation, general regulation. That can be a breach of FET, and we see a lot of cases. And there is no exhaustion of local remedies. I mean, a law of parliament, a regulation of the government, you don't have to take that to an administrative local court. No, you can go directly to investment protection at international level. Then you have administrative acts of the state directed towards the investor. The mayor who prohibits access to the mine. And there it's the same. The standard is FET, whatever it means, and there is no exhaustion of local remedies. Paulson has said in one decision, I think it's Plama, that, well, there is no exhaustion of local remedies, but please do not come to international justice when it is a very low-ranked official who takes a small decision that it must have a certain authority within the state. But that's a very weak standard. And then the third point is you have judicial decisions from the third power of the state. And there, well, Leuven, and I think it is basically Leuven who then sets this principle that there you incorporate customary international law. Exactly why in that case you incorporate customary international law in the previous two you do not, I really do not. It's their interpretation. And then you incorporate it but you incorporate it not pure, but with its added requirements. And it is now, since this law derives from decisions which are not binding, but when there are 25 decisions in the same, there is not one single decision which disagrees, I would submit to you that that is now international law. This is how the principle works. We can discuss how, as Carolyn was saying, exactly how you define denial of justice, whether you put in discrimination or not. You can discuss, and very much so, what implies exhaustion of local remedies when the local remedies are inexistent, unreasonable, or have no chance of success. We are discussing, and we do continuously discuss these minor items. But the whole structure of the system, I think it is now set in stone.
Yeah. Do you think it would make a difference if it's the executive branch or some sort of government organ that initiates the lawsuit in the first place, and so achieves what it could have achieved through its own unilateral action, but then goes to court and does it, and now we say, oh, you have to go through denial of justice because the court has put a stamp on a government. Under the existing law, do you think that's how it would play out? That you'd have to proceed through denial of justice?
It's a very, very good question. So what you are basically saying is a state then says, no, I will not expropriate myself, I will ask a judge.
Right.
You get there, and I cannot give you an answer because I really have never made a decision on that, and I don't want to prejudge that. But it is one of the questions I really struggle with in this area is whether there can be a judicial expropriation, when a judge can in fact not issue a judgment, but what he does is an expropriatory act. And then your question is very, very, very well placed, where in that case you really have to exhaust local remedies. It's a very intelligent question. If you want to write a paper on that, I think everyone would be enlightened, and I really don't know the answer.
Thank you.
Well, thank you so much, Juan, for coming here, for sharing all of your comments, thoughts, and the wonderful descriptions of the cases that before this none of us had known. So thank you so much.